Hello friends, in the series on the income tax cases, today we will discuss the case of New Noble Education Society versus Chief Commissioner of Income Tax. This case has been reported in 448 ITR page number 594 and the matter has been decided by Honorable Supreme Court and the date of the judgment is 19th October 2022. Although already we have made video on this case, but I thought that some points were missed in that deliberation which are very important for the understanding of this case. So I am also covering those leftover points in this case. In this case, when this judgment came on 19th October 2022, the Supreme Court specifically overruled its earlier decisions on section 10 subsection 23C. These cases were American Hotel and Lodging Education Institute, Queen Educational Society versus Commissioner of Income Tax, second case, and the third case was additional CIT versus Surat Art Cloth Manufacturers Association. In all these three cases, the Supreme Court has given the judgment that if the predominant object of the educational institution is education, then it is suffice to give them exemption under section 1023C. The word solely was not strictly followed. But when the judgment came in New Noble Education Society, the Honorable Supreme Court made a shift from the object predominant object to solely object, meaning thereby that an educational institution cannot exist other than for the object of education. Solely means exclusion of other things. Although in this case also the Supreme Court has elaborated that some activities like transportation activities by an educational institutions for carrying the students from their home to the school and vice versa, and if some bookstall is there in the schools which are selling the books to the students of the school, then these activities still will be covered. But other than those activities, if the profit element of the educational institutions will be very high, then it will be seen with the colored glasses. If we see the law on charitable organizations in other countries, then the law is not like that. They say that if the profits are earned by the educational institutions and they are reinvested for the purpose of the education, then solely on the basis that they are earning profit, their exemption cannot be denied. But the situation with the interpretation of this case is a little bit different. Now the organizations which are having handsome profit due to their efficiency, even in those cases, the exemption under section 1023C can also in danger. As all we know that whenever the Supreme Court judgments come, they are applicable from the date when from the date when that section came on the statute. For example, this case is regarding section 1023C. So it will be applicable from the date when section 1023C came on the statute. But in this case, it was specifically mentioned that this case will not be applicable retrospectively and this case will be applicable from the date of the judgment. The reason given for this prospective application was that the Supreme Court wants to give the time to the organization to adjust themselves according to this decision. But if we practically see, this decision will be applicable from the date it came on the this decision came. But how is it possible for the educational institutions to adjust themselves in a few hours of the implementation of this decision? So practically the organizations will not get the time. So the government should think about the proper implementation of this decision. There is one basic difference between the enactment and the judiciary decisions the enactment says that what the law should be, and when the judgments come on these sections, they say that what the law is. So by this interpretation of this judgment in this way, this case is very important and have a crucial role for all those organizations which are claiming exemption under section 1023C. They have to see that they are not showing very big profits, although this case can motivate them to adopt some malpractices to show their book profits at a lower level, but that practice should not be adopted by any institution. At the end of this video, once again I am repeating the name of the case. The name of the case is New Noble Education Society versus Chief CIT, and this case has been reported in 448 ITR page number 594, and the matter has been decided by Supreme Court, and the date of the judgment is 19th October 2022.